read that last comment. He didn't make me a doctor, but he made me a little old. So in terms of what everyone talks about, the Courier case, let me start there. That was 1998. This was a case before the Supreme Court of Canada. This is what has defined the law for the criminalization of HIV transmission. Factually, it dealt with a man and a woman, non-disclosure, no transmission of the virus. And the court went up to the Supreme Court, and they had to really they had to change laws on fraud to try and set what the law would be for this kind of case. So what the Supreme Court there said was, you have a situation of consensual sex. The consent is going to be vitiated. The consent is going to be negated where there's fraud. But the fraud, the elements of the fraud have to be first the deceit or the non-disclosure. And then there has to be, in order to meet that test of fraud, what they term that, in this key phrase, a significant risk of serious bodily harm. And I listened to what Jessica said, and the problem is, I'm before the courts trying to explain what is a significant risk of serious bodily harm. The courts are grappling with what is a significant risk of serious bodily harm. And what has happened, if you fast forward then from 1998 to 2012, there have been a lot of developments, a lot of, fabulous medical developments. And the courts are looking, and they have to deal with each different kind of factual situation. So there you had, sexual intercourse unprotected at a time when if you got HIV, you were likely to get AIDS, and you were likely to die. Now, the courts have had cases where you've got oral sex, you've got ejaculation, you've got non-ejaculation, you've got, all the different sexual acts. And, there are judges who then have to determine, well, does this constitute a significant risk of serious bodily harm? So we rely on experts. And I rely desperately on these experts, first of all, because they have to train people like me, who didn't study medicine and statistics, to study all these different studies so that I can thoroughly understand them, and that I can then, with the expert, argue them before the court. But you have different experts, and then what you have are battles of different experts. And you have, in terms of situations, for an example, with oral sex, there isn't any statistical risk. There are no studies, to my understanding, that determine risk from oral sex. And someone who's a medical practitioner is going to tell their clients, it's a low-risk activity. But there are statisticians, there are experts who will come to court and say, well, I'm going to attribute a statistical risk to this theoretical risk. And then they're in court saying, well, and if you've done this theoretical risk 10 times, it's 10 times the statistical risk, and that's a significant risk. And so you have a battle of different experts before the judges. So the battles are many. Then you get to the key issues that are coming before the Supreme Court of Canada. So now with the advent of antiretroviral therapy, you have individuals who pose no significant threat. They virtually are uninfectious. They have an undetectable viral load. They are still charged. And you are still put into, and I'll talk about what happens to someone when they're charged. But so you've got that key issue that's before the courts, and that's what's going before the Supreme Court of Canada. One man was convicted at trial who had an undetectable viral load, was appealed, and he was acquitted on those charges at the Court of Appeal, and now it's coming before the Supreme Court of Canada. Also, the situation where you're practicing safe sex, you're wearing a condom, that's what public health tells you to do, and yet you're charged with aggravated sexual assault. Aggravated sexual assault normally has dealt with historically a violent rape, and that's the offense that people are charged with. There there is no consistency, and I have people who call me and they don't know, and people are scared. They don't know, am I going to be liable to being charged with aggravated sexual assault, potentially attempt murder? And there's not even a clear answer. I mean, I'm hoping that the Supreme Court of Canada clarifies it. I'm hoping they clarified it in our favor and narrow these issues so that it is only, unprotected intercourse where where someone is significantly infectious. These are so these are the key issues. There are some cases that are simply ones of credibility. Someone says there was disclosure, someone says there wasn't. And so like other charges, it's a he says, she says, and then left before the court to decide. Being charged is devastating. Let alone the battles that I have to fight to make sure that people aren't convicted. Just being charged, having your picture plastered in the newspaper, as a serious sexual predator. Anyone who's had contact with this person, contact the police immediately. They have traditionally said in the newspapers, this is someone with HIV. As of late, they sometimes have a serious medical disease, and it's pretty clear. And then, my clients have had, cuffs slapped on them, dragged into jail, and for the most part, I'm dealing with people who never had a criminal charge placed against them. I've had the Crown's battle to try and keep people in custody, and when they don't succeed in keeping people in custody, they're under incredibly stringent bails, where all your freedoms have been stripped from you while you're awaiting. This is under the presumption of innocence, while you're waiting what can be a very long time before you get to trial. In cases where someone is convicted of aggravated sexual assault, heard with the kinds of penalties, and these are for where there's no transmission, you're looking potentially at a penitentiary sentence for someone who's never committed a criminal offense in their life, or something that's close to it, 18 months of jail. Certainly, jail for someone who has HIV, jail is not a healthy place to begin with. The other consequences are put on a sexual offender registry. So for 10 or 20 years, you were deemed, a serious sexual offender who has to disclose to the police every time you change your address. Every time there is some serious sexual offender on the loose, they can come to your employer, to your neighbors, and to you to inquire as to what involvement you might have had. Forget crossing the border into the United States. There is, even for people, and there has been, I've seen certainly in my practice, a tendency in Ontario where some of the greatest number of prosecutions are in Ontario, where some Crown attorneys have looked at a case and said, this case is not in the public interest to go forward to trial. But even for those people, the repercussions have been devastating. The ripples that go on in someone's life are significant. So what the Supreme Court of Canada, and I expect you to understand the issues that's being argued on behalf of the defense, is it does not meet a significant risk of serious bodily harm when someone has an undetectable viral load, someone wears a condom, that there is not, and they shouldn't be convicted. The flip side, as I understand some of the arguments that are going to be made, are going to be the sort of the moral argument that can be compelling, certainly to some jurists, that someone who wasn't bargaining for anything, that any risk is significant to them. And I guess what we have to hope is that doesn't resonate, that the courts really understand and appreciate what Justice Corey said in Currier, is you don't want to trivialize the criminal law. These are significant and harsh penalties, and you don't want to make the criminal law into, did someone say they love you? And it might be morally wrong, but it is not a serious criminal offense. So I'm going to be there, watch the arguments, and hope my family